So Ravi, finally,
We're doing it.
yeah. I think after 1.5 years,
Yes, maybe. Yeah. February 2024.
I think that was when you were dealing with the PMLA matter
PMLA
in High Court.
matter in High Court,
High Court of Telangana.
Telangana. It is disposed.
I think appeal was also filed, right?
Yes, it is also disposed. So, yeah, finally, we're doing on the subject.
Yeah.
PMLA.
Before I was thinking, like, when even VirtuaLaw approached us for a podcast, I was thinking what should be a relevant topic. Then I was always right from when I became an insolvency professional, one thing which was like consistently chasing me was, why is it that PMLA versus IBC is a debate even today?
Yes.
Right? I mean, Supreme Court was dealing with it for quite some time. And it's really surprising. Why is it that they still feel there is some level of dispute between both the acts and there is need of time for the Supreme Court to decide on it? While IBC specifically says that, it overrides every other thing. Now, that's something which I always felt strange. Why is it that it's still prevailing?
The interesting thing is both are special laws.
Yeah.
And one more interesting thing is PMLA and IBC were enacted by the same government, NDA-led government. That's an interesting aspect to deal with it later. It's a political thing. I don't want to comment. But that's an interesting thing that these are economic legislations in a way. One is to prevent an economic offense. One is to promote entrepreneurship and other things.
Yeah.
Both have an economic facet to it.
True.
So let's dive into this in detail, and we'll also find out why this debate is still there.
Absolutely.
Which law overrides the other.
I really like this idea that we both can go, try to be as, extempore as possible, in the sense that whatever I think is relevant, I'd like to ask. And I think whatever you think is relevant, I think you please try to share.
Let us keep the conversation open
True.
so that we'll also go home pondering on the new ideas that we discuss.
Agreed.
Yes.
But Ravi, I think before the podcast, you explained me one interesting aspect of money laundering. I think that was, I really learned it for the first time, why they named it. It never occurred to me that there was a prehistory behind, or there was a history behind the terminology of money laundering.
Money laundering, yes. Because when we were discussing this week, I just wanted to brush up a few things before getting to the podcast. So, interestingly, what I found is that the money laundering, it is a common belief that the monies that were being accumulated by an illicit activity are cleaned. How a washing machine does it. The laundering service. But what I found interestingly is that this nomenclature has a history. It was said that in 1970s, Al Capone, one of the notorious criminal in United States, so he has earned so much of the account to money, what we say, or a black money, or a monies which were earned from criminal activities. So what his modus operandi was, because in US, unlike our country, they have a huge public laundering services where weekend they go into the laundering services. There would be restaurants.
You see a lot in sitcoms.
Yes. There would be restaurants. They would launder their clothes, and this importantly is a business run in cash.
Yeah.
Because it's a cash-run business, this mafia notorious criminal has opened huge laundering services across the country. The money was, the business was going on in cash, is giving services. While doing this official, what do I say, it's a legal business of laundering services, because it is a cash-run business, he has brought in his illicit money into this account and he has laundered it. So literally.
Using fake invoices.
Fake invoices, he has inflated expenses and many other things. So FBI has identified that, because FBI has found this thing that they have identified few patterns that how, because yes, they all know that he's a notorious criminal. He is earning his money through illicit, but he's spending it legally. Then when they backtrace the trail audit, everything, they have found this. Then the nomenclature eventually and naturally evolved into this money laundering, giving it an official term. Then the UN taking up, then Ronald Reagan fighting against drugs, money laundering. the financial task force that been promulgated by
even till date,
United
the financial
Nations.
task force is still active.
It's still active. It's still
even
active.
At the time of opening bank accounts, they do have some level of norms.
Yes. So that's an interesting thing of PMLA. And then UN, the United Nations, has passed a special resolution where we were a signatory member. As a part of that, in fact, we have enacted this law.
Correct.
Though it was enacted in 1999, where a bill was introduced. In 2000, the bill was passed. Only, if I'm not wrong, subject to correction, in 2005, it came into force, this law. So it's a very small special legislation. The definition is a very small definition, one section definition. There's only the section 3 defines what a money laundering is.
Okay.
Section 4 defines what's a punishment for the money laundering.
Okay. Those are like the kind of the enabling sections of
the enabling sections. So we will go into this just at the overview. Then there is agencies. Now the very famous enforcement director.
I should tell you this. When I was appointed as an IP of it's an individual insolvency, RP of an individual person guarantor.
Yes.
He had debt sales of around 10,000 crores.
I remember.
You're the counsel for that. So I was told he was arrested. I was clueless. I was supposed to serve the notice that you are under insolvency, and out of curiosity or whatever, I just went to the ED.
Yes.
I was sitting in the ED office. I can see that fellow sitting there, arrested by the ED. It was one of a kind of experience because it's not like a police setup.
Yes, definitely.
I was seeing the ED officer, see the kind, my memory, if my memory goes right, he was sitting in front of his table is bundled with documents. Unlike a police station, it's bundled with documents. He's wearing a normal formal shirt and like a government employee is sitting there. And my fellow, the guarantor is sitting somewhere in the corner. And he was arrested. So this guy says, who are you? An IP? I don't know who is an IP. What is IBC? We don't care about all that. Whatever you want, you go to the special court. And then I realized, okay, there's a special court for the PMLA. That's a criminal court which is dealing with
the criminal liability of money laundering.
So, since you mentioned ED.
Yes. Because now as we are dealing with the subject PMLA, the ED plays a key role.
Yeah, definitely.
There is a twofold liabilities that were prescribed under the law. One is a civil liability and the criminal liability. Because the very objective of PMLA, which says that the act was enacted to prevent money laundering.
Correct.
Which is a criminal nature. And to provide for confiscation of property acquired through money laundering.
Proceeds of crime.
Yeah. Which is a civil in nature. Yes. Because it deals with property. Attachments, confirmation of attachments, if it is proved, confiscation. And then again distributing it to the claimants.
Correct.
Now when yesterday, when we said that how will we take? The ultimate objective of IBC and the PMLA, in a way, I see it as the same thing.
Okay.
What is happening? It's an interesting thing. I was just drawing parallels to IBC and PMLA. IBC says there is a debt company. We will restructure it. The law provides for corporate restructuring. At the same time, providing a waterfall mechanism of distribution of the assets of the company.
Correct.
Either if it is a successful resolution, the successful resolution applicant would come, give a bid. He infuses money that would be distributed. If it is the last resort of liquidation, the liquidator will sell the assets. It would be distributed to them. Ultimately, the assets of this distressed entity or a new RA coming in infusing money is being distributed to its creditors. Rightful claimants. In fact, though the code IBC says creditors, in a way, they are claimants.
Absolutely.
What is PMLA doing? PMLA also says doing the same thing. PMLA says that so-and-so has committed an offense of money laundering.
Correct.
And these are the proceeds of crime. So the ED comes, it
attaches it.
As an executive agency. It issues as a provisional attachment, which is valid for 180 days. Then such an attachment has to be confirmed or rejected by the adjudicating authority within 180 days. Once it is confirmed, it is valid till the trial is disposed of.
Yes.
Either way, as a
As in
conviction
favor or against.
acquittal. If he is convicted of the offense, then this confirmed attachment would result in confiscation. What happens after confiscation? Confiscation is assuming the property to the government itself.
Correct.
Now the government says after confiscation, within 30 days, they invite claimants who are bona fide claimants. They come saying that due to the offense of money laundering, I have suffered a quantifiable loss and I have taken a due precaution to avoid this, and I am not involved in the money laundering offense. Then it says that okay, it will collate all the claimants and it would distribute this thing. What is ultimately the monies have been distributed to the claimants.
Correct.
Now, when in such a scenario, I don't think so that there must be a fight or inconsistency. Why? When the addressing the elephant in the room, which law overrides the other? Is it the PMLA overriding IBC or vice versa? The thing is that till now the courts have held that there is no inconsistency amongst the provisions, because the non-obstante clause, as you are aware,
both the laws have
it starts by saying that wherever there is an inconsistency, this law will have an overriding effect over that law. They are saying that there is no such provision in PMLA and IBC which are contradicting one another, which is inconsistent to one another, because it is dealing in a different realm and it is dealing in a different realm. That being the case, the only question that it boils down to the point that what about the assets? When one law is saying that you may take custody, control and sell it off, and you are saying I will hold this asset, who must yield to whom? Then a natural recourse available under the constitutional law when two entries, because all we can see how to construe two legislations is we have a commonsensical principle of harmonious construction. So that so long we are dealing with the subject of prevention of money laundering, PMLA will apply, and so long we will deal with the subject of restructuring a company, IBC should prevail. There should not be any harm, or there should not be any mischief in interpreting both the things. So, and we'll discuss how the remedies available under PMLA would help IBC.
I think that's extremely important.
That's very important. Yes.
To secure the assets.
To secure the assets. So long there was a confusion. Even I would admit that, because the amendments were very later. Only in 2019, the government, I think maybe with the difficulties being faced by the distressed companies who are also been involved in money laundering, they have amended certain provisions of PMLA rules, confiscation of the restoration of confiscated property rules, where it said that till then it was only provided a remedy that only what happens after confiscation. I was earlier telling that once a property has been confiscated of which is involved in offense of money laundering, the invitation of claimants and other things. Now they introduce a new rule, a new rule, which says that 3A of PMLA, restoration of confiscated property rules. The amendment was brought in 2019, where it says that during the pendency of the trial of this money laundering, a bona fide claimant may make an application to the special court and show a sufficient cause of being a bona fide claimant, can be entitled for the restoration of such attached property. And now you're also aware, IBB is managing us to make issued a circular saying that identify. Yes, very recently. So identify wherever it is applicable, approach special courts. And to be very honest, Prakul, the special courts and the agency as well, I have to give credit to the agency and agency's prosecutors as well. They are not objecting the RPs or the liquidators, or in fact any bank for that matter.
Correct. Even the secured creditors.
Even secured creditors.
Even on the surface, they're doing it.
Yes, they are doing that. Where their surface rights are frozen due to attachment.
Yes. They are approaching the court.
They are approaching court and hassle-free. In fact, the promoters are objecting in such applications, but agency is telling no, please go ahead.
It's probably a matter of time, but
yes, as things are getting settled and more understanding of both the laws, even the prosecutors and the agency as well is giving no objections. I'll not name the cases, but they're giving something like, we do not have any objection to restoration. But if there are any monies over and above satisfying your own legitimate claims. In a case I'm telling about a secured finance creditor, where they said that due to a particular right, I'm filing this restoration application. The agency is telling that no, we do not have any objection. You adjust, we are free to restore the property, and the special court may restore the property with only condition that these X may be the legitimate dues, and by
anything excess of it
may be deposited with the agency.
Okay, makes sense.
Yeah, it's a very logical.
Yes,
it's a logical end to the entire problem.
Agreed.
Maybe in this way we need not enter into the realm of whether which law prevails over the other, IBC or who has supremacy. We need not go. But when there is a scope for harmonious construction of two legislations, I think that should be a better thing to do.
Okay. But just one question there. Does it matter as to when we created the security interest? Like for instance, let's say it's a proceeds of crime, right? Ultimately, the object of why we attach a property is because of an assumption that it's a proceeds of crime.
Yes.
Or rather that the money is a laundered money through which you would have acquired this asset.
True.
And let's say the act for which the ED is contending this to be a proceeds of crime had occurred even before the security interest has been created.
Yeah, actually, yes, that's a very important question, even as a professionals, for us to understand. Not only as a lawyers and you as an insolvency professional, even for the bona fide claimants, the most cases where the cause of action originally has been arose. So, before going to address that particular question, we'll once examine what PMLA provides the definition of the proceeds of crime.
I agree. Let's park this question.
Let's park this question, and we will examine what the proceeds of crime means.
Okay.
As per Section 2, where of Prevention of Money Laundering Act, it's a definition clause. 2, subsection 1, clause U.
Okay.
Which is the proceeds of crime. It says the proceeds of crime means property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. Proceeds of crime explanation also says, for the removal of doubt, it is hereby clarified that proceeds of crime include property not only derived or obtained from the scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offense.
Okay.
So it says that very clearly, what a proceeds of crime is: a property derived or obtained by commission of an offense,
as a result of that activity.
As a result of a criminal activity relating to a scheduled offense. Now, what for our viewers, like what is scheduled offenses? PMLA provided a schedule where it has enumerated a list of offenses under various laws. There's IPC, certain provisions are there, which is, then NDPS is there, then many other. Just to give a quick overview of what the schedule is. Schedule consists of Part A. Part A includes offences under offences under Indian Penal Code. No, BNS it may be. BNS, maybe it has to be read down. The offences under NDPS, Explosive Substances Act.
Correct.
Unlawful Activities Prevention Act, Arms Act, then Wildlife Protection Act, Immoral Traffic Prevention Act, Prevention of Corruption Act, Explosives Act, Antiques and Art Treasures Act, SEBI.
Okay, even offenses of the SEBI.
SEBI, it says that prohibition of manipulative and deceptive devices, insider trading and other. The acquisition of securities and control. If these are the schedule acts: Customs Act, Bonded Labor System Act, Child Labor Prohibition Act, Transplant of Human Organs Act, Juvenile Justice Act, and Passport Act, Immigration Act, Foreigners Act. So it goes on. It's an enumerated list.
Okay.
Now it's a very exhaustive list. It has a
understood.
Part A, Part B, and Part C.
So technically it is kind of choosing what are the offences laid out under various legislations, which are kind of criminal activities concerned with money laundering.
Money laundering. So it says that more or less, if we examine detailedly what the scheduled offences are in detail, those are the offences where by committing those offences there would be a monetary benefit.
Understood.
These are such an offences. Cheating, for example. There is in IBC, there is cheating has been involved. Forgery has been involved. So when these certain things or like certain these kind of offences are made, these are directly related to monetary benefit. There would be a monetary benefit to such an accused. When there is a monetary benefit, then there would be a need for that particular criminal or an accused for the conversation's sake until proven guilty is innocent. I will not say criminal or say accused. Because he has earned something by committing a criminal activity, he has to launder it. He has to make it a clean money to use it legally.
Correct.
There, the application of PMLA comes into picture. Well, this law wants to prevent such a laundering service, like what Al Capone has done in US. Being this the proceeds of crime definition, now what actually the law has prescribed money laundering to be? It says that whoever directly or in section 3, offense of money laundering, whoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including concealment, possession, acquisition or use or projecting or claiming it as untainted property, shall be guilty of money laundering. So the main definition is in the proceeds of the crime, and whoever is directly or indirectly attempts or indulges with the proceeds of crime or projecting it to be an untainted money is committing the offense of. What is the punishment, Prakul, for this? It says that minimum 3 years, a rigorous imprisonment, minimum 3 years, extended up to 7 years. But however, there is one exception that if that offense, if the scheduled offense is relating to NDPS, then it is extendable up to 10 years because it deals with the narcotics and psychotropic substances and illicit traffic of drugs and other things which are like deteriorating the society. There is a moral turpitude involved and the punishment value is high. So now coming to your question, if what would be the time of registration of the security or where a secured lender has a mortgage from the borrower accused. Now, at which point of time he would be considered to be a bona fide claimant?
Correct.
Now, ideally speaking, this must precede the offense of. Ideally, this must precede the offense of committing the scheduled offense.
The timing of committing the scheduled offense.
Because committing scheduled offense, as a result of committing a scheduled offense, you have acquired something.
Agreed.
So, being a bank, ideally what happens? They would cheat the bank and they would siphon the funds.
Yeah, practically that's usually how this happens.
This is the commission. By this result, he is acquiring some property. And then he would do something to project it as untainted money, or then he would commit the money laundering.
Correct.
Either ways, banks precede this event. Because in most of the cases, where most of the
property is acquired by raising funds
from the bank. So in most of the cases, they would be a bona fide claimants because they are the victims.
Yeah, because they have funded the acquisition of the property in majority of the matters.
In majority of the things, but not knowingly.
Okay.
The only catch for the only exception that is given to who is a bona fide claimant is that he has taken abundant caution. He has done his due diligence and he is not involved in the money laundering because he would be because he is the victim. He in the first place he was the one who has been cheated. But they are saying that no, I'm raising this project, I'm doing that. Then he siphons or violates all the conditions of the contract.
If I may pause you there, See, assuming the banker is a scheduled bank, I buy your argument that they are the victims. Let's talk about NBFCs. We know there are multiple NBFCs in the market. Few NBFCs are, of course, all NBFCs are regulated by the RBI, but there are certain NBFCs who fund certain transactions, and there might be a possibility of a promoter trying to, have some level of control with the NBFC. Or let's even leave even NBFC. Let's say some other creditor, some person has funded this. Okay, let's say some XYZ. He doesn't have any lending license, purely a loan agreement, funded it through his own sources. Okay, there's a security document created, charge created, and that guy is also one of the accused in the PMLA application. Okay, the ED has a prima facie application against him, stating that he's one of the accused. But it's not the property owned by that fellow, it's a mortgage property. They have attached this property. Now he, using his mortgage rights, okay, he's an accused, but there is absolutely nothing. I mean, because like at times there are pro forma parties because of the kind of apprehension.
Because there is a transaction and you are a party to transaction, they want to make you a party.
Yeah, if at all, let's say that's how they have come up with. And that fellow files an application for restoration of the property. Does ED have a discretion to object, or is it like ED cannot object? What's the law? Like, is the law, does the law say that, boss, if there is a secured asset, there is a perfection of title of the security interest, ED cannot object it? Is that what the law says, or is there a scope for the ED to object it and stay, and try not to release the property?
Yes. So, what does law say? Is very important for us to examine one definition. What a claimant.
Okay.
When such a mortgagee, he would be as a claimant approaching the special court. The provision says that when a property is confiscated within 30 days, because once he's convicted, the special court convicts a particular accused on guilty of committing money laundering, the property which was attached earlier and confirmed by the adjudicating authority would stand confiscated. Confiscated by the central government. Now, after confiscation, it gives a right to the claimant. It says where a notice to be given in a wide circulate newspaper, and then 30 days time would be given where they would submit their claims, establish their bona fides. Now it has defined what a claimant is. Now a claimant, what actually under law, these rules define what a claimant is a person who has acted in good faith and suffered a quantifiable loss. There are two things. One, that there is a bona fide, he has acted in good faith and suffered a quantifiable loss as a result of the money laundering, as a result of the offense of money laundering, having taken all reasonable precautions and is not involved in the offense of the money laundering. It has given 4 parameters. One, that he must act in good faith. 2, that he has suffered a quantifiable loss. 3, that he has taken all due precautions. And 4, he is not involved. These are the things to be satisfied. Now, while making an application, the applying the principles of natural justice, the ED, the agency, will have a right either to object or to give a no objection on conditions, or may say any other things or bring on certain facts which this applicant would not bring to the notice of the special court. In the most of the cases, given the scenario which you were narrating, the one is he's not acted in a good faith because he is also an accused. Then what is that quantifiable loss he has suffered when he is also a party to the money laundering? So by establishing this thing, where again, earlier you were telling that how NBFCs or a promoter approaching an NBFC, not a scheduled commercial bank, because being an NBFC, it would obviously suffer a quantifiable loss because interest would not be provisioned.
Agreed. And
the accounts would be defaulted. At least in their books, there would be a default.
Correct.
There is a quantifiable, there is a loss which is quantifiable.
Agreed.
And due process is what they have to show their documentation, that how they have conducted that there were precautions being taken. And they have to establish, this is a case-to-case basis, that
Understood.
They have to establish that they are not involved in this process of money laundering.
And one final question to this link is, who has the onus of proving this? Is it the ED who has to prove otherwise, saying that this fellow does not have the bona fide, or he's not he's not suffered the loss or something, or is it the applicant who has the onus to convince the court that I meet all these 4 criteria? Who has the onus?
The onus is on the claimant.
Claimant, sorry, yeah.
Who is approaching the special court. The
So
onus is on him.
On the claimant. So claimant should, beyond the reasonable doubt, convince the court.
Yes.
It's a special court, right?
Yes, it's a special court.
Yeah.
There's the special court, and it says that the special court may. It's a discretionary power vested in the special court where a sufficient cause has been established by the claimant. Any equity.
Yeah.
Because he has suffered they suffered a loss due to the commission of the offense of money laundering.
Yes.
Had it in ordinary course, he would not have suffered.
Agreed.
And this property for a very long time being attached. And he, though he may have any right, either a SARFACI right or any other right in equity, his rights froze because of this attachment. So he is coming to the court and establishing a sufficient cause was, I have suffered this loss due to commission of this offense, and I am a bona fide guy, and I do not have any particular involvement in this commission of the money laundering, and I have taken due courses. These 4 parameters which we have earlier discussed, and court being satisfied, it will restore the property.
Understood.
And then his rights would continue.
Great.
In ordinary course of the law.
Okay. So I think you tried explaining section 3.4.
Section 3.4.
Yeah. Okay. So the punishment is done.
Punishment is done. So now earlier we have started that how this PMLA has created 2 kinds of liabilities. A civil liability, a criminal liability.
Yes.
We have seen that civil liability, because there are 2 objectives of the PMLA. One is to prevent money laundering. The 2 is to provide for confiscation of the properties acquired through commission of money laundering.
Okay, can we pause there? Let's just discuss about the objectives for a while.
Yes.
See, you said there are 2 objectives.
Yes.
I just found it a bit interesting. I don't know why. Just thinking out loud. It says to prevent money laundering, and second, to provide for confiscation of property derived from money laundering, right? Or incidental to money laundering. Now, when I look at the definition of money laundering, it is an act which had already happened. Well, the law is to prevent it. So, are there provisions to prevent the money laundering in the first place, or are there provisions to attack after money laundering has taken place?
Very interesting question.
Because I really felt the definition per se is an act which has already occurred.
Yes. See these, because being a professional, these are continuing acts.
Yeah, agreed. Okay.
These are continuing acts because money laundering, because he continues to earn from the illegal activities and he continues to launder it.
So even the next step is something. Even though one act had happened,
though it has started,
if you would have stopped it at the first act, it technically means you have prevented the future acts of money laundering. Okay.
Yes, because that's why very important thing while prosecuting a money laundering case is that they say the predicate offense. The predicate offense must be proved, because the money laundering will be proved only if it is proved that you have committed some scheduled offense.
Agreed. Yes.
if in the first place, if
that wasn't, you were not able to prove that, then there is no case against it.
It would not fall in the definition of proceeds of crime, because it must be a result of a criminal activity, of a scheduled offense. Now that the criteria would be that a court must convict for the predicate offense, or that the scheduled offense has been committed, and then then one step, then it is committed. Then we will deal with money laundering. Then this is also been committed, and on independent evidence basis, that 1, he has committed an illegal act, 2, that he is also committed an act to clean his money. So you have seen that to prevent the money laundering is a criminal liability, where the criminal aspect of it, of the law, and to provide for the confiscation of property derived from the money laundering. With the civil law. So what provisions it has created is, it has not created any agency by this law. It has empowered an agency which was already been there, the Enforcement Directorate. Now, Enforcement Directorate's history goes back to 1950s. It's a very age-old agency which started with a law officer and 2 inspectors or so, and then they've changed its name. I was going through their website and their history. It's a very interesting thing that they say that they've started in 1950s. They say that in 1956, they started as an enforcement unit in Department of Economic Affairs for handling exchange control laws and violations of erstwhile FERA of 47. Then the new FERA in 74 has come. So then they have totally full-blown unit has been renamed in 57 as the Enforcement Directorate. That FERA has again been repealed and it is FEMA has 99. Been enacted into FEMA of 99. Then by this PMLA, they have also entrusted the existing ED of FEMA to handle the PMLA.
Understood.
As on today, they handle 4 laws.
Even the fugitive economic offences?
Yes, the new 2018 bill. So they handle cases under FEMA, PMLA, the fugitive economic offenders, and there is one more that they would do is, one is PMLA, FEMA, fugitive economic offenders, and they are also a sponsoring agency to COFEPOSA, which is a Conversion of Foreign Exchange and Prevention of Smuggling Activities Act, 1974. The ED is empowered to sponsor cases of preventive detention with regard to the contraventions of FEMA. So it is in interrelation with FEMA and COFEPOSA. So these are the laws that they. Now what the PMLA provides is, when we deal of civil liability, Section 5 is a very important section, if we may see. Okay. Section 5 says that attachment of property involved in money laundering. It's an executive action. Attaching in itself is an executive action. Attachment in itself is a civil action. Point number 1, it is a civil action. The first action by the law starts with the agency itself. The Enforcement Directorate is empowered under Section 5 to provisionally attach any particular property where they have a reasons to believe.
The authority to attach comes from with the ED itself.
With the ED. So that's why we say it's a provisional attachment, because it cannot exceed beyond period of 180 days. So within on 180, after 180 days it expires. So before 180 days it must require a ratification, because it's an executive action, because it's an unilateral action.
Yeah, correct.
The offender or the accused is
never had a principle. I mean, never been given an opportunity
of being heard.
Yeah. So, and I think this goes in line with the prevention of money laundering, right? The objective. Because when ED knows, with the kind of facts they have in place, if at all they start the initiate litigation, that would have alarmed the accused, and that would make him prepared to do things. Whereas ED comes, as a surprise, that would definitely be in furtherance of the objective of prevention of money laundering.
So they also say reasons to believe.
Okay.
Now, and what an attachment is, because it has 2 things. Because the early provisions of Section 5 deals with immovable properties, where attachment is pertaining to immovable property. They can also seize movable properties. The law provides for that.
Okay.
Either attachment of an immovable property or seizure of and retention of movable properties. Because, for example, money is lying in an account.
Yeah,
they are movable.
Equity share.
Exactly. So the definition of attachment means, again, 2(1)(d) says, attachment means prohibition of transfer, conversion, disposition or movement of property by an order issued under Chapter 3. Chapter 3 is where we are seeing section, that starts from Section 5. Now how this comes upon? The Enforcement Directorate issues a provisional attachment. Let us deal with immovable properties.
Immovable property.
Then it applies same thing. Immovable property, Section 5 says the agency may attach provisionally for 180 days. Before 180 days, on expire, 180 days, the provisional attachment expires. Before that, they apply to the adjudicating authority. There are rules. Immediately upon issuing a provisional attachment, they must make an application to the adjudicating authority. This is an authority created by this law. So we say adjudicating authority, PMLA. It is kind of a quasi-judicial body where it provides an opportunity to the offender, the prosecution, anyways the agency itself is filing the case. Everybody would be issued a show cause notice, and to show them they may agitate their case. And then then the adjudicating authority under section 8 will either confirm or reject. If it is not confirming, automatically it
It's a
expires
rejection.
on 180 days.
180, yeah. I think that's an
Once-
interesting provision. Yeah.
Once it is confirming, so section 8 provides for the adjudicating authority and the procedure with the adjudicating authority and its power. And if it is confirmed by adjudicating authority, the next remedy available is any person aggrieved by the orders of the adjudicating authority, they may approach the appellate tribunal under section 26.
Okay.
Now 8 says that the adjudicating authority may approve. This is adjudication. It says there is a creation of an adjudicating authority where adjudicating authority either it may confirm the provisional order or it may not. If it is not doing so, in 180 days the provisional attachment order would be expired. Now the next remedy is section 26.
Okay.
Section 26 says that the director being an agency, if there would be a situation where the adjudicating authority may not confirm an order.
Correct.
So the provision provides the remedies provided to either to the agency or any person aggrieved by the order. They may approach to the appellate tribunal. Now, what is this appellate tribunal? This is a very interesting thing. I may slightly go outside the topic, but very interesting thing. Originally, this appellate tribunal is an appellate tribunal for forfeited properties. Okay.
Okay.
So this is
a designated authority.
Yes, this is an appellate tribunal created under SAFEMA. Today also we say that appellate tribunal SAFEMA. Even if we go to the Delhi.
Yeah, true.
So SAFEMA is a Smugglers and Foreign Exchange Manipulators Forfeiture of Property Act 1976. Appellate tribunal created under that law is today the appellate tribunal under PMLA. What the central government has done, in fact, this is one of the early tribunals that have been created for the because it has dealt, it deals with SAFEMA and Customs Act, and it's a very interesting thing. I must note it. It deals with SAFEMA, NDPS, PMLA, Prohibition of Binami Property Transactions Act. So this is a consolidated tribunal for all these offences, majoritarily involved in economic offences. So there the appeal lies. There it is headed by usually retired High Court judges. So it's same. There would be opportunity given to the aggrieved party, the agency. If agency being the aggrieved party to the accused, then it gives an order. Either it will say that the adjudicating authority's order is upheld or it is set aside. From there, an appeal lies to High Court. This being an appellate tribunal, because ultimately it's a quasi-judicial body. It's a creation of the statute. Then there is a statutory appeal to High Court. And then it freezes. The law provides the appellate forum till High Court.
Okay.
Where High Court will decide a case whether this attachment is valid or not. This is the civil side of the the civil aspect of attachment. And similarly, it is also for the movable property seizure, search, retention. It has every other powers. It is dealt similarly. Now, this is the civil aspect. Now coming to the criminal side of how the proceedings would go on. What generally ED has is, like we all know, FIR, First Information Report. What in ED cases it is ECIR, Enforcement Case Information Report.
Okay.
So basis this is the first document of the investigation. Basis this, they issue a provisional attachment. So this precedes provisional attachment.
Okay. But without a notice.
Yes, without a notice. It is. This is the stage where it is at this stage where the accused would be arrested. ECR.
Okay.
So what precedes ECR? The registration of FIR under the predicate by the predicate agency where a scheduled offence been committed. Generally, CBI. For example, we have seen the schedule. There is Prevention of Corruption Act.
Correct.
Maybe the Anti-Corruption Bureau of Anti-Corruption Branch of CBI registers a case under PC Act. By that being a predicate offence, the agency would take cognizance and then it would investigate, and it would.
If there's a prima facie case,
the first thing is ECIR. Basis that, if after investigation concluded, they will make a complaint to special court. Now the PMLA has created a special court for trying the offences of money laundering. Now it says that it is a court which has been designated by the High Court Chief Justice, where in consultation he will designate a particular court to be a special court, where for example, in Hyderabad, it is Nampalli Metropolitan Sessions Judge is being designated as Special Court PMLA. All the PMLA cases will be dealt with that particular court. Now, upon completion of investigation, generally in an ordinary offense or in an ordinary case under CRPC, would be after the FIR culminates either in a final report where we say that the FIR is closed, that there are no charges, that the police, after completing investigation, could not charge a particular accused, or if there is a charge, they file a charge sheet. In ED cases, after investigation, they file a complaint. They file a complaint with the special court. The special court would take the cognizance of the complaint and issue summons to the accused, and the trial goes on. And the provisions of CRPC are applicable. Okay. How an ordinary trial is being conducted to any other case, a similar fashion, in a similar manner, this has also been done. Now, at this stage, after trial, if the special court, the charge of the agency, the prosecutor is that he has committed section 4. There is only 2 offenses, only one offense, money laundering. Then there is a punishment. The trial goes. The special court will say either you are guilty of the offense, convicted 3 to 7 years, or if it is an NDPS being a scheduled offense, 10 years. And then confiscation comes in. The appellate remedy, appeal lies with High Court. This is the criminal side. Now, apart from this thing, there is one more right, a substantive right being given to the claimants. Earlier we are discussing. In 2016, the central government, because 8.8, there's a provision 8.8, very important. Well, let's once go through section 8 when there is adjudication happening. I was telling you about the confirmation of confirmation of the provisional attachment by the adjudicating authority. Once read section 8.8, where a property stands confiscated. Now, when confiscation happens after the special court has found the accused to be guilty of the offense, where conviction, where the PMLA case is resulted in a conviction. The property is confiscated. Where a property stands confiscated to the central government under subsection 5, the special court, in such manner as may be prescribed, may also direct the central government to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of offense of money laundering, provided that special court shall not consider such claim unless it is satisfied that the claimant has acted in good faith and has suffered a loss despite taking all reasonable precautions and is not involved in the money laundering. The 4 parameters which we further, that the special court may, if it thinks fit, consider the claim of the claimant for the purposes of restoration of such properties during the trial of the case in the manner as may be prescribed. Now, the as may be prescribed, the central government has prescribed the rules. Now, central government has prescribed PMLA, restoration of confiscated property rules. Originally, in 2006, they have provided for these rules, where in 2016 there was no during the trial, the later part. It was an amendment, I think, of 2018, which during the trial restoration. Then in 19, they have amended and introduced subsection 3A, by which during the trial, once a complaint is filed and trial commences, and during the trial also, claimant may approach the special court, get their property restored and enforce their own rights.
That's what I was about to ask you. It is during the trial, technically meaning that, so when it says during the trial of the case, it technically means the property is not yet confiscated, right?
Or not yet confiscated, yes.
That's the provision.
Technically, yes, technically. Because maybe this is the logical end to the issue, because there is a property deterioration. Because there is no proper mechanism
to preserve
the property.
In fact, not even at the most they'll do is to secure the property. That's all.
That's all.
Whatever rental income from the property is gone. People don't intend to buy the property.
Yes.
The value of the property deteriorates in the market.
Yes.
If I may ask one question here, if you think it's relevant, you can answer it right away, or maybe we can park it aside. I heard, and also probably during our discussions or probably in other matters, that the accused is allowed to substitute the property which is confiscated with the similar value. Is there another property bearing similar value? In which case, the property which is attached as a procedure of crime might be released, and it will be substituted with another property being offered by the accused, with a similar value. Is this how it operates?
I don't see a very straight provision for it.
That's my question. Actually, there is no such provision as such. But in practice, it's something which is allowed, right?
No, I don't think so in practice also, because I don't see the viability how the law operates that way. Because the people generally say, even I also
to offer that. In fact, in the same matter, I hope you understand.
Also, but I don't think so. There is a substantive provision which enables either the agency to release or to do such way.
Even a special court also might not have that authority to do,
because
considering the
law provides the value thereof. When they say value thereof, they may attach the value thereof of the yield of the or the result of the criminal activity, where the money which has been
correct. And the moment you substitute it, the very fundamental basis of attaching the property is gone.
I don't see a straight provision. We do not know. Maybe there were cases or where the court has, in its discretionary powers, must have.
But it should be subject to facts. I don't think it's a precedent.
It is not a precedent, and it is not a law also as on today.
Understood.
Because that, I think that defeats. Maybe I don't know how because in a court of law we can only enforce the right which has been vested upon us.
Yes.
What we say is a positive law. There must be law rooted in a particular legislation or a statute.
In order for me to even go and ask for it.
Yeah. Because if I go with this proposition and the judge is like, show me where it is. It's a practical difficulty.
Yeah. Okay. So
8.8 we have seen.
Yes.
Then we have seen the restoration of the property. Now coming to the IBC. Because how IBC starts, the IBC, the triggering event for IBC is a debt and default.
Default, yeah.
Because I'm only giving I'm in a scenario where there is an offense of money laundering, there is a company, there is IBC, there is PMLA.
Correct.
The triggering event for IBC.
All checkbox ticked.
The triggering event for IBC is debt default.
Correct.
He has cheated the bank. A predicate offense has been committed. He has been defaulting with the bank.
Correct.
That is a triggering event for IBC. The banks, having to exercise their rights, they've approached the adjudicating authority under IBC. The CIRP has been initiated.
Parallelly, they would have also filed a FIR.
Yes. They must. In most of the cases, this financial applicant, creditor
might be a willful defaulter.
This financial creditor who has initiated Section 7 under IBC must have been the complainant of the predicate offense as well. We do not know.
Most likely.
Let's
assume so.
Yes, scheduled commercial bank, yes. Most likely. So it starts with the appointment of the IRP can come into RP, and declaration of moratorium. Now, if the scenario is that prior to the declaration of moratorium, if the things have been attached under PMLA, a different thing.
Yes.
Or after commencement of the proceedings under IBC, if the agency is attaching, that is a different thing. Whether that would be a violation of moratorium or not. Because the moratorium has been commenced.
Correct.
The moratorium provision says that prohibits. It's a prohibition on continuation of proceedings or initiation of a new proceeding.
Yeah.
I myself have secured an order from adjudicating authority under IBC that for a violation of moratorium, the attachment during subsistence of moratorium under Section 14 IBC, an attachment made by agency is void.
Okay.
the adjudicating authority has declared rightly. There was a company, it was put into CIRP. After putting into CIRP, despite giving the intimation
of
the
moratorium.
agency has attached the properties, the adjudicating authority declared that this is a straight violation of Section 14, and it has set aside the attachment. And I think it has been successfully liquidated also, to my knowledge, because I was later not part of that particular assignment, the council. But to my knowledge, I was told that the part assets were sold. So that is the thing. What happens to the cases where prior to the initiation of CIRP, they have been attached? Now the cloud has been cleared by the IBB's recent circular that the IPs are advised to approach the special court.
Format has been
given. How to? I think even I was seeing. Because when we make the application to show my bona fides, I would go on and on and on and on. No, they have given a format readily.
Saves that time. And in fact, that's an indication that probably there is a prior consultation between IBBA as well as the agency. ED or maybe the ministry as such. Right.
Interestingly,
it's the same ministry, right? So definitely the departments, Department of Offences and the Department of Ministry of Corporate Affairs.
That might be because there's an insertion of one of the provision to PMLA where they have appointed, where they've created an interdepartmental agency. If I'm not wrong, it's a 2019 amendment. Just the benefit of our viewers. Yes, I was just telling that there is in 2019 amendment, they have introduced a new provision, 72A, Interministerial Coordination Committee. The central government may by notification constitute an interministerial coordination committee for interdepartmental and interagency coordination for following purposes, namely operational cooperation between government, law enforcement agencies, the Financial Intelligence Unit India, the regulators or supervisor. So I think maybe they might, or we are just seeing something this thing.
No. I think it makes sense, no? Because it has come in 2019.
2019,
right? Yes. And it's a new insertion, right? I mean, it's an insertion of a new section.
Such consultation among, yeah.
I think more or less this is kind of that
policy cooperation. They say that policy cooperation and coordination across all relevant and competent authorities. So I remember an early case. Maybe this is a very famous case of Satyam case. There were so many cases in the Satyam.
The Mahindra Tech.
Yes, the Mahindra Tech. But to my when I recall, there's a 2018 order passed by Telangana High Court where it has quashed an ED attachment. It's very interesting to observe. I've just shared that judgment to you.
Yes, I do have it. Yeah.
I'll just read out for the benefit of our viewers and for us as well to understand what the scheme was. It has highlighted that it has, as pointed out by Supreme Court in Vadilal Chemicals Limited versus State of Andhra Pradesh, the state, which is represented by various departments, should speak only with one voice. And it narrated what has happened in Satyam case. It is very interesting to see that when the Ministry of Corporate Affairs swung into action within 48 hours of discussion made by the disclosure made by the managing director of the company, the object was to save more than 3 lakh shareholders, 53,000 employees. After inducing the petitioner herein is Mahindra, the after.
Yes.
After inducing the petitioner to infuse funds in order to rehabilitate the company, the Satyam Computers, it is not open to another department of the government to treat a portion of what was part of the assets of the company at the time of competitive price bidding as proceeds of crime liable for the attachment and confiscation. Now, what has happened in Satyam case is today's IBC. What has happened in Satyam case within 48 hours of disclosure of this scam by the Satyam Raju, MD? The corporate Ministry of Corporate Affairs have come into action. It has superseded the board.
Yes.
Now, what is happening in IBC?
The RP superseding the board.
The moment CA, either a section 7, 9 or 10 is admitted, CIRP is initiated.
Yeah.
The moment it is initiated, moratorium is declared. The powers of board of directors are suspended and vested with the interim resolution professional or the resolution professional, whatever the case may be. It's the same thing.
Yes.
Then they have called for competitive bidding, induced the petitioner. Now what does we call
the EOI.
EOI, the Form G, we issue expression of interest, we publish.
Yeah.
Then the prospective resolution applicants come in. We share the information. They become successful resolution applicants. They infuse funds. This is what has happened.
Correct.
When this is in a more elaborate way. What they've did in Satyam's case, they with a more exhaustive provisions and more elaborate way, they've brought in IBC.
Correct.
Now, when such a company a distressed company is put into insolvency, the process run, and a successful resolution professional, a successful resolution applicant has taken over the company, they've distributed the assets to the claimant, to all the creditors. Now, what would their treatment with the ED or PMLA attachment or any other proceedings? The immediate right answer that is available to us is 32A.
Yeah.
Section 32A says that the prior offences, the offences committed prior to the commencement of the insolvency, CIRP, shall stand extinguished.
Yeah, shall cease.
Shall cease. To what? Only to that corporate entity.
Correct. Against as
it is only restricted, it is only applicable to the corporate entity.
Correct.
Which is going through the insolvency. That's all. Because ultimately a company cannot commit any crime per se by itself, because there
should be some motivation behind it.
Yes, it's not a living thing.
Correct.
It is only a artificial juristic person.
Yeah.
By lifting the corporate will, the promoters would be there, the key managerial persons would be responsible for committing offense. That is not spilling over to that personal liability of any individuals or whatever in our corporate law language we say officer in default.
Correct.
It is not applicable to any officer in default. It is only applicable to that entity. That's the benefit that any SRA is taking when they are acquiring a company.
In fact, since you quoted 32A goes on to explain that any action against the property will also include attachment, seizure, retention, and confiscation. The term confiscation should ideally be read for PMLA. In which ways it is very clear statutorily that once a plan is approved, and it is approved in favor of an RA, resolution applicant, who has nothing to do with the existing management, not related. In which case you can't continue any action, including confiscation, attachment against the properties, as you rightly pointed, of the CD, corporate entity.
And there is a double layer of scrutiny because there is a 29A as well.
Yes.
So 29A
you're not allowing
has fortified that nobody can take a benefit who has already been a defaulter or anyway. So you are not putting the same persons in charge, so that you are not whitewashing the things.
Yes.
So it is a bona fide benefit giving to a third party who is rightly working to the objectives of the code. He is promoting entrepreneurship, he is improving the credit availability, he is maintaining, he is striking all the balance amongst the stakeholders. All the objectives are ticked.
But this reminds me of a recent JSW order. I mean, of course, thankfully they filed a review and then they recalled the order and passed the fresh order. But if you go by the first order, what it effectively tried to do, or rather if I have to reiterate the facts or look into the facts, there was a plan which was approved by the COC, approved by the NCLT, all things are going good, then PMLA comes into picture, or rather the ED comes into picture and attaches the property. Just imagine the stakes involved. It's a 19,800 crore plan. You submit it when there was no attachment. The NCLT approves the plan, there was no attachment. Suddenly an attachment comes. Obviously, the RA is not is going to pay for that particular asset and distribute it to the creditors and still take the hit of an ED. So what they did, I think after 2 years, they entered into an arrangement saying that fine, we'll still make you the payment, but this will be subject to the outcome. So in an event of an unlikely outcome against us, then you need to return the money. That was the arrangement with
the creditors
creditors and the SRA, and they paid 19,800 crores towards that. And surprisingly, Supreme Court says
that you have failed to implement
because there was a delay. Seriously, 19,800 crore.
The terms of approved resolution
are violated. I mean,
and that's a very sad state of affairs as we right now.
Just now you read out a lot.
The two
departments having two different voices.
Various departments should speak only with one voice. And now that SRA, because the moratorium under 14 ceases upon the approval of resolution plan, we cannot take the benefit
of moratorium as well.
But this is exactly what has happened to Satyam.
Correct.
After post-acquisition by Mahindra, this is exactly which was quashed by our courts.
True.
So to have a logical conclusion of what we are having the discussion, I am only reminded of what Justice Rohinton Nariman and Swiss Ribbons as when a constitutional challenge of all the provisions of IBC the code were under challenge. He took those petitions and he spoke for everyone. The Supreme Court, in his voice, has spoken that. To stay experimentation in things social and economic is a grave responsibility. Denial of right to experiment may be fraught with serious consequence to the nation. It is one of the happy incidents of the federal structure that a single courageous state may, if its citizens choose, serve as a laboratory and try novel social and economic experiments without risk to rest of the country. He quoted a Supreme Court of United States judgment where their federal structure permits a particular state, but our union would not permit that. But however, the intentions were that where a socio-economic legislations, when we deal with the socio-economic legislations, the experimentations comes without saying. I see that all the insolvency professionals, we as a lawyers or anyone at chambers and all the professionals, from being CA, chartered accountants, company secretaries, everyone, our own offices are laboratories.
Correct.
We experiment with our own cases.
Agreed.
We take a decision.
Yes.
Especially, I'll put myself aside because me being a lawyer.
We do take decisions, yeah.
So, IPs
based on the opinions.
IPs take decisions, chartered accountants take decisions, company secretaries take decisions. No, these decisions are only put to challenge in court of law. The court would say whether your decision is right or wrong.
That's where the jurisprudence
where jurisprudence is evolving. Yeah. But who is doing the experiment?
Correct.
It is the you professionals. So we generally say, we have to say, it's the constitutional notion that Parliament makes the law and courts declare the laws. I can say that when it comes, especially with commercial laws, especially with socio-economic laws, the professionals play a very key role in declaring and making the laws. I do not say making the laws, but an instrument to courts to declare the law in a particular way.
Correct.
It is not that they are doing something. They are doing the law made by the Parliament in a way which is more suitable or more convenient or more beneficial way to the many stakeholders.
Definitely.
And with respect to PMLA and IBC, I see that both being socio-economic legislations and beneficial legislations. They're for the benefit of the people. All the competent authorities or any authorities, in my own personal view, I think that they must take a liberal view, a liberal, sensitive view, that they must give way to, because bringing an investor is a very hard thing. Nobody, they're putting their money, they're putting their hard-earned money.
That's the heart and soul of IBC.
Yes.
Bringing an
investor is, so the entire objective or the result or the fruits
is at stake.
Are at stake.
Agreed.
And without their cooperation, without the cooperation of the agencies, and without a liberal view being taken by the competent authorities, the results would be hard. Yeah. Or sometimes what we have seen in JSW would happen.
Yeah, 100%.
Where if
and even after all this legal battle, the core question of the attachment of assets is still intact. Even for the JSW case. Yeah.
And I think some case would come where the interesting thing we all know, because the PMLA Act has Section 71, which says that non-obstant clause, overriding act to have overriding effect. But there is a subtle difference between the non-obstant clause in language of PMLA and IBC. PMLA says the provisions of the PMLA shall have an effect notwithstanding anything inconsistent therewith contained in any other law for time being in force. Now coming to IBC, it's an extended definition. It is the provisions of this code of IBC shall have effect notwithstanding anything inconsistent therewith contained in any other law for time being in force, or any instrument having effect by virtue of any such law. It also overrides an instrument. That's how they are changing the priority of charges.
Correct.
One of the objectives is to alter the priority
of charges
of payment to the central government. The IBC is such a beneficial legislation. It wants to give an overriding effect, to give a clean slate ultimately. To give a clean slate is something very novel, and it requires immense commitment or immense sacrifice sometimes for the government also, because now the new bill, because we are speaking of this new bill,
the winter session is definitely going to allow it.
Most sure to what we've known that before the finance committee for its report on the bill, and committee has invited many representatives from various stakeholders. They have deposed before the committee. So most probably the bill would be passed in both the houses and it would come into force. One of the central governments, it's a very novel action. I should applaud the central government on this thing. They have introduced an explanation to the definition of security interest. They say that the security interest shall be, the proposed bill contains, the security interest shall be only by an instrument
and not by an operation of law.
And not by the operation of law. They're giving up their right.
Yeah.
The controversy
explicitly.
They've given up the right, because though the courts have ruled in their favor in particular matters.
The rainbow. Oh my God.
They've ruled. They're saying that by operation of law.
Even till date, a lot of departments are of the impression that they're secured.
They're secured.
They wouldn't have even read the order.
Yes.
But when they come file the claims with us, they come with an impression that it is secured.
They say that in CIRP they're secured.
While in liquidation they're not.
In liquidation Paschimanchal judgment, they say that no, because in 53 you have put in a particular way.
So therefore you have to be treated that way.
You put in priority in a particular place, so you wouldn't have a benefit over or pari passu with the secured.
It's a different debate altogether.
The central government taking this stand, giving up on revenue is never, because from where we have come where?
True.
During colonial time period, the crown debts have priority. Yeah. They said that
the top priority.
Whoever you're being secure.
Yes.
In UK also, you're being a secured creditor, fine.
Yeah.
But debts due to the government
always have the top priority.
They must be paid in priority.
Yeah.
From there, they have altered the priorities. One of the objectives of the code to alter the
objectives.
priorities.
It's one of the objectives. Yes.
To alter the priority. Then the Supreme Court has the highest court of this country said that now, because by operation of law they are entitled. It only said that they are entitled.
In that particular case,
But they gave up. They gave up for whom? The central government has gave up their priority by operation of law to whom? To the beneficial claimants like banks, or the other operational vendors,
all of the stakeholders technically.
So the benefit of our investors, because none. I don't see any beneficial investor who coming and wants to pay to the statutory authorities.
100%.
Because they think that it is a penal, it is an inaction of the erstwhile management, that it's their fault. It is not the asset that is being. With their own legislations, the statutory legislations, the penal, the tax legislations have provisions for that to go behind their promoter. If the corporate will, they are amply protected. But this action of giving up thing is what I think should be an influence for PMLA and IBC as well, because government should do that. Because unless
they come up with that clarity. Because if I become an RP of a company which has got assets attached with the ED, it's a tough thing to sell. Because it will be very difficult for me to go convince an investor, and the investor will look at it as an opportunity to further bargain with the creditors. That's the biggest challenge.
They are seeing as a leverage to
bargain. It's a leverage to bargain, true. Somebody who knows, like as you rightly said, the rules which have been framed for release of restoration of confiscated property. They may know the law, they may have people like you to assist them, but still they'll use it as a leverage because of the time involved in the litigation, the cost involved in the litigation.
But I think this circular where the recently IBBA has issued to all the RPs, and taking this route would maximize the value of the assets of the company, of the corporate debtor. It would definitely, because now this leverage or this bargaining effect would go for toss. completely, because I am getting it restored. Now you come by as if it is a normal property. It has been restored to its status quo ante has been restored.
Correct.
What exists prior to attachment is there today. So don't speak of PMLA. That is now between those people who are facing the allegation, not the assets of the company. So I think a logical conclusion that as government is given up its priority over taxes or the
similar approach
dues,
should come.
similar approach should be a limit. I'm not saying that they should completely waive off their substantive rights or the prosecution on the PMLA cases, but to the company assets at least, because ultimately the sufferer either is the public money, the banks, or somebody who has bona fidely paid them. They should not be
put to this
hardship.
And in fact, I think ultimately it's just a way to 32A.
Yes.
Because I think the law is there.
Because I don't think it's other way. Because earlier also we were discussing this. What will happen after confiscation? They are also saying we'll invite claims. The same thing.
The same thing. Yeah.
The transparent manner. It is not that there is something behind the doors is what contemplated on the law. It's a transparent manner. Anytime they can verify the claims, everything is uploaded on the website.
Yeah, it's all
IBBI. It's so much transparent. As a regulator, IBBI is doing a great job.
Yeah.
Unbelievable job. Because as a regulator with such a less experience, 9 years, 10 years, it's a nascent regulator, but it is doing wonders. It is facilitating, even as a professionals, you and me know, their support services is unbelievable. They're away. They're like a minute away from the call, what we say. They're always supporting.
Definitely.
And I not only this thing, not only this restoration case, whenever there is a shift in law, the IBBA is very quick and in assisting or issuing a facilitation letters or other things. The motive, the main objective to maximize the value of assets is clearly been seen in the intentions of the regulator.
Agreed.
Now, it's the only question left is with the government.
Yeah.
With this bill, I think that their approach is shifting.
Yes.
The shift is there. I can see the shift. And I think
similar approach might also be followed.
I think these kind of cases would now be sorted. And I don't think so. This would be a big hurdle, as we've seen in the early stages of IBC.
That's there.
That's there. We are improving. The departments are slowing down. On things. Because they've also understood that.
I think the awareness is also
the awareness has been improved. And they've also understood that truly, yes, the sufferers are somebody else. Simply by holding the assets or stalling the resolution process is not fetching anything.
Definitely.
Only the solutions, the true solutions are only in resolution. A successful implementation of CARP would benefit on one. If you could recall, day before yesterday, the central government has notified the new labor laws. A successful implementation of a CARP would also benefit the laborers,
100%.
the skilled, unskilled workmen, employees, to
the economy.
The economy. The other one, who has facilitated the credit. Yes, they are being benefited. The business is run.
The scope for new credit.
There is the scope for new credit. The going concern is going on.
Yes.
We are keeping.
So I think all these factors should be factored into before ED takes a call, final call.
ED takes a final call. Maybe I think a new synergy must come.
100%.
I think
the 32A should be followed.
Either the law must. I don't. That's only my personal opinion that either if there is a particular company or a particular companies or a group companies where they have seriously committed something very wrong in the eyes of the government, prosecution, or for the benefit of the public, in the interest of the public, ultimately, it must come with a caveat that it must be in the interest of company. They cannot take benefit of that. They must exempt it from IBC if they truly want to do so. But once it is put into IBC, it is for the public.
Correct.
They cannot do so. And even if such a company is exempted for IBC, there must be an equivalent provisioning or equivalent remedies as we give under IBC, like where there is a scope for putting a claim. There are remedies, because you're saying no else court can pass any order. The executions of decrees are being stayed. That powerful the law implementation of the moratorium is.
100%.
You're seizing a decree. the highest thing in equity. What a common man can have a ticket apart from the decree.
Correct.
You're seizing the execution of a decree. But the process, we are saying that we will give that benefit through a different way. When such an, if the government tomorrow thinks that a particular company in the interest of public must be exempted from IBC or CIRP, they bring some legislation to that effect or a provision inserting by amendment that particular sectors or particular companies are exempted. So which government can do? They can exempt from moratorium. They can do so.
Yes.
They're rightly. Under 14, they can issue a notification and this it shall be not applicable to a particular sector. They can say, every power they have.
Yeah.
If they do so, they must bear in the mind that an equivalent remedies must be available to the public, who are sufferers ultimately. And I don't think so, because as we have discussed elaborately, the assets, the corporate entity, the promoters are to be seen differently to have
100%.
effective resolution.
Yeah.
Going back to corporate law 101, Solomon versus Solomon, must be always born in the mind.
Correct. I think
So,
we'll end it here.
yes.
I think we should take an oath that we should come back with more interesting topics.
Yes, we'll come back with a new issue.
Yes.
Maybe, yes, we'll see, because the new bill is coming. We can discuss that, and there are many more issues.
Yes.
You and me,
Yeah.
we see every day. We'll come back soon.
Sure.
Hope we meet again
Yes.
soon.